How you doing?
Good. Last name?
I'm here in regards to...
Tyler Rock.
Yeah,
Portland
no.
Avenue, dry suspend, unpaid fines.
Okay, I'm not sure what's going on. She didn't give me any tickets. She has no copies of anything, just the police notes here.
Yeah, she looks like she was given disclosure on May 27th. Yeah. What's she planning on doing with the charges?
Well, all I'm seeing here is some officer's notes.
Yeah, that's the disclosure. There's a copy of the information.
Okay, well, where's the cause of action?
I'm not aware of what you're saying, sir.
You're not aware of what I'm saying?
No. And if that, you can talk to the court. She's been served and she's here.
Cause of action?
I don't know what you're talking about, sir.
Okay, so what am I doing here today?
I don't know. What are you doing today?
Well, she told me that she's supposed to be here this morning, so I'm here.
Trial date or what? What did she tell you to do?
Well,
Do you have written instructions from her?
I'm acting on behalf of it.
Do you have written instructions from her?
Are you saying I need written instructions from her?
You will. The court's going to say you need written instructions.
I will get written instructions from her, but we're looking for a motion for a cause of action.
You need to have written instructions from her. You can't act as her agent. Are you a lawyer or a counsel?
I'm her father-in-law.
Yeah. So to have it, the court's going to say, without written instructions from her, we have no proof that she's told you to be here. I'm not saying that you don't, sir, but I'm just saying that's what the court's going to do.
Okay, well, we need to have a show of cause of action.
Forget the show of cause of action. You don't even have standing with the court at this point in time.
I'm not sure the court has standing. The prosecution has standing here, isn't it?
I'm not going to have a discussion with you. I'll talk to you right now. Come on in. I'll be right back. Good morning, Your Worship. For the record, Cotter, C-O-T-T-E-R, initial R, here is agent as well for the Attorney General. Just speaking to one matter, sir, with permission. I don't have my jacket on. I don't offend the court, I hope, in any way.
Sir, you're in a shirt and tie.
Thank you. Line 181, there's a Tyler Rock, your name for the record, please.
I'm here regarding the matter.
Just step forward, sir. And your name for the record, please.
My name is Rob Smith.
Okay, and you are here on behalf of Tyler Rock?
Yes, I am.
Okay, and what's happening in this matter?
What I can advise, sir, is he's identified himself to me as, I think, the grandfather, is that correct?
No, I'm her father-in-law.
Father-in-law. And I asked him if he had instructions today, written instructions to appear on behalf. And I said, it wasn't so much that I doubt him, it's just that the court needs to know that since he's not a lawyer or a paralegal, that he needs to have written instructions to act on behalf. I don't believe he does, but I'll let you make that inquiry. I said, you're probably going to need to adjourn to get that. So.
Okay, what was going to happen today? Was it going to be for the purpose of a plea?
I'm not 100% sure what the plan was today. I don't have tickets. I don't have a show of a cause of action here. All I've got is some officer's notes. And apparently this is the full disclosure. So I was going to ask for a show of cause to see what we're doing here in the first place.
Okay, well, first of all, without proper instruction, it would be, and this is a charge under the Highway Traffic Act, dry well suspended.
It's a dry suspense, sir, serious matter.
I don't know what the Crown's position is at this juncture, but...
If I need written permission from Tyler, I can get that from her.
I think...
And we can adjourn until then.
Just a moment. Just give the court a moment, sir. I don't know what the Crown's position, this is where I'm going, sir, it's drive under suspension. It can carry a jail sentence if the Crown seeks it. And so without proper instructions, sir, we suggest that we put it over to another day. You can appear as her agent, and if she wants to resolve the matter, you can appear, but I would suggest that you bring, be able to satisfy the court that you have permission, that she's aware that you're going to appear as her agent, and deal with the matter accordingly. So the Crown can provide disclosure this morning, sir.
Disclosure was provided, it says to a friend, was that Mr. Smith that it was given?
It was provided to Staley, Margaret Staley.
Who's Margaret Staley?
That is a individual who, it's another relation of hers. She's no longer going to be involved with this due to some issues that they've had.
Well, that complicates it even further.
Yeah.
The disclosure should be requested from Ms. Staley and provided to you, sir, or the defendant.
And I believe for the record, sir, the gentleman has showed me, he has the disclosure package that was provided to Mr. Daly in his...
Well, the only thing I've got here is some officer's notes.
Okay, that's
So-
probably, yes.
So what I can advise then, sir, maybe we should adjourn this so you can get written instructions. I don't think we need to adjourn it a long time to allow that to happen, and then we can proceed. Also, as you noted, sir, on, I'll just tell Mr. Sorry, what was your name again, sir?
Smith.
Sorry, Mr. Smith.
Rob Smith.
Mr. Smith, I did note that he has the green sheet that tells him how to meet with the Crown to have a resolution meeting on Monday afternoon. So he can do that in the interim once he gets instructions from that individual. So whatever date you'd like to, sir, to have it returned.
Yep, I'm familiar with this, yeah.
Yeah, and there's the resolution times. So what date would you like it to come back, sir, to allow you to get instructions?
I don't have a,
We have August 26th available, that's 2 weeks.
It's always a Monday,
it's
so.
always a Monday. August 26th should be good, yeah.
Okay, so August 26th, sir, that'll be for 9 o'clock, returnable to this courtroom number 1. You will get a reminder slip, sir, and if your instructions are to resolve the matter, then it can be dealt with that day, sir.
Okay,
Thank you, sir.
have a good day.
Thank you.
If you don't come back before this court, sir, you'll either have to satisfy the court's way of presenting a letter, or that satisfy the presiding justice that you have permission to deal with the matter, and she is aware that you're dealing with her matter, and you can satisfy the court.
Yep, I'll get that done.
Thank you, Richard.
Morning, sir. Morning, how you doing?
I'm good. What was the last name?
Ross.
All right, is your
Daughter-in-law.
daughter-in-law, right.
Yeah.
And you and I met,
A couple times.
I think. We just had a resolution meeting last week, I think, if I recall.
Oh, we discussed, yeah.
Just trying to find-
And I gave you the instructions that I was given from Jen, what she wants me to do in the matter.
Now, what does she want to do? I know that we talked about if she gets her driver's license back, 32-1. Do you know if she's planning on doing that, or
Sorry, if she's what?
planning on doing that?
Doing what?
Getting her license back and taking the 32-1, or are we going to set a trial date?
32-1, what do you
That's
say?
the drive no license, with the $260 fine, no demerit points, and no license suspension if she gets her license back.
She's got her license back already.
So does she want to do that, or?
She's willing to do that as soon as you can provide cause of action and standing.
Well, I'm not going to be doing that, so we'll just set a trial date.
You're not going to show us why we're here.
You've seen it. She's been served with a summons. That's why she's here. And there's a charging document before the court. So, I mean, if you want, you can take it. She's already joined the jurisdiction for you. If you have instructions to do the guilty plea, you can do it.
I'm sorry, can you say that again? Something about what?
She's here. You're here on her behalf.
Yes.
So she's already returned to the court's jurisdiction. All right?
How's that?
That's what happens when you appear before the court. She was given a summons and she's appeared before the court. Now, if you want to argue that point, then we'll set a trial date. If she wants to do the resolution, then we can just do the guilty plea and be done with it.
Okay. The thing is, you're saying she's returned to the summons.
So not me, the court's going to suggest that she has. You see, the problem is you can't come before the court and address the court and then say I haven't returned to the jurisdiction. If you don't accept the jurisdiction of the court, you can't make argument to the court. It's kind of like saying, I don't think you exist, but I'm going to tell you why I don't think you exist.
See, these are the questions I've got for you guys that I've been trying to resolve and find out so I can present them to her and get a resolution, get a solution from her as to what to do.
Yeah, so the offer is, as I gave to you on August last month, 19th, I think it was.
So you're saying just because she walked into the courtroom, she's pleaded?
No, she hasn't pled. But she has a torn, the legal term is, she's a torn to the jurisdiction. Even if she didn't walk into the courtroom, if that summons was signed by an officer saying that I served her personally, we'd have jurisdiction over her at that point as well.
We're not questioning the jurisdiction of the court, okay?
Yes, and then
We're questioning the jurisdiction of the officer in the charge in the matter.
well, then you need to set a trial date. And the problem is that if she fails on that argument, then she could be convicted of the dry suspension, which is a $1,000 fine and a 6-month license suspension.
And I've explained that to her, and she's still got the questions, so...
Well, then we'll set a trial date. She either accepts the offer for the plea, or she sets a trial date. I would suggest that we probably need to set... So you going to represent her?
As far as I know, yeah.
Okay. She can still do that, but she needs to let us know if she wants to do the plea, because we need to set it for trial. And then she can say, okay, I'm going to make that argument that...
Like, I'm going to hold this offer still open.
Oh yeah, the offer will be open until probably the week before the trial.
Okay.
Because I don't want to waste time and bring it up. If you take the deal, then I'll just cancel my offer and away we go.
Okay, November 22nd?
Is that a Monday?
No.
No, it's a Friday.
Okay, Mondays are preferred if we could do
We
that.
won't.
Mondays are always the set date for
Yeah.
it, so we never
Okay.
have it on Monday.
November 22nd, that's a Friday, you said?
Yeah.
At what time?
9:30.
9:30.
In the morning. Okay, yep.
Well,
And how much time did you
I
want?
think we'll set it down for an hour. It sounds to me like it's on the resolution track, but you go to get instructions from her, okay? November 22nd, 101,
101 at 9:30.
9:30. Okay.
Okay? So if I can get your signature there, you're just signing that your word's going on November 22nd for trial.
Yeah, that's just confirmation that that you know that date's okay.
It's just which, sorry?
That's just confirming that they're accepting November 22nd as the court date.
You'll get a slip of paper in the courtroom with that.
And they'll give you the date in court, and I'll take this file in so you can head in, and we'll see you in a minute.
You want to take mine in?
Sure.
I'm here regarding that matter. My name is Rob Smith.
And what's the relation?
She's my daughter-in-law.
Yes.
First appearance?
No, Your Worship. I have a certificate of compliance setting a trial date in this matter of November 22nd, 2013 at 9:30 a.m. Courtroom 101 for 1 hour.
And what's the date of the offense?
August 5th, April 5th, 2013, Your Worship.
Thank you. When the matter is set for trial on November 22nd, 2013, court 101 at 9:30, 1 hour. Thank you.
If I may personally address the matter of Richard Henhofer, line number 19. Good morning, morning, sir. Surname Henderson, first initial W, appearing as agent of Mr. Henhofer, anticipating a guilty plea to the charge on amendment. And that amendment is to a charge of speeding 65 kilometers and opposed to 50 kilometer charge. That amendment's on consent, Your Worship. It's an informed plea. I'm not sure whether you allow waiving or range. I'll waive the Yeah, I'll waive the range and enter a guilty plea on behalf of Mr. Come up, sir.
Come up to the microphone and state your record, please. Thank you, sir. Your name?
My name is Rob Smith. I'm her father-in-law.
Okay, that's fine.
The fact that the request of discharge is marked as withdrawn.
Thank you. At the request of the prosecution, the charge against Ms. Rush has been withdrawn.
Thank you.
Thank you, sir. Have a good day.
Line 20.